is a petition being filed by Mr. Menzies' counsel. And as many of you know, that has already happened. It happened last Wednesday. I believe that's July 16th. So after the judge issues the death warrant in a death penalty case, the petitioner has 7 days to file a petition to the Board of Pardons and Parole. The state then has 7 days to issue its response. That 7 days will be up tomorrow. And so at the end of business tomorrow, by then the state will have filed its response. That begins step 2 of our process, the review of the petition and response. The board will then review both of those documents to determine whether there are genuine issues that should be addressed in a commutation hearing. In step 3 of the commutation process, the board will decide whether or not to grant or deny a commutation hearing. The decision will be announced by the board and posted on its website at bop.utah.gov. Now, as it may be clear, if the board decides to deny the hearing request, the process will stop at step 3. But if the board decides to move forward and grant a commutation hearing for Mr. Menzies, a hearing will be held. The petitioner may present testimony and provide an argument concerning the issues related to the petition. The state may also present testimony and argument against the petition. Victims will be granted an opportunity to participate. And the hearing will happen before the full board at the Utah State Correctional Facility. If the board decides to grant a hearing, notice of the hearing will be posted on our website and on the state's public meeting and notice website. Once the hearing occurs, the decision will be made by the board after the full hearing is complete. The board will determine by majority decision whether to grant or deny the commutation petition. And that decision too will be announced by the board and will be posted on our website. Those are the 5 steps of the process that will happen in Mr. Menzies' case. I'm happy to answer any questions that you may have.
Good morning, Jennifer. There are currently only 4 members of the Board of Pardons and Parole with the departure of Sheriff Scott Stevenson.
Yes.
Who will be the 5th member if this goes forward and there is a commutation hearing granted?
Great question, and it's actually a little different than that even. So in Mr. Menzies' case, we have 1 recusal of a board member who has had involvement in the case and so has recused. So we actually have 3 full-time board members who will be participating as part of that panel, requiring us to use 2 pro tempore members of the board. Currently, there are 4 members. So the 2 that the board who will complement the full-time board members are Bradley Rich and Bob Yates. So both of them will be serving to review the petition, to review the state's response, and if there is a hearing, will serve in that capacity as well.
Which board member had to recuse his or herself?
Mr. Dan Bakavoy. Mr. Bakavoy, as you know, worked for the Department of Corrections prior to coming to the board.
That makes sense.
Will the hearing be streamed online again, or how logistically will that work, media access-wise?
So we are planning on live streaming the hearing. We will also, as consistent with many processes for hearings by the courts, we will have a pool media option.
And when can we expect to hear about the hearing?
So as I said, the state has not yet submitted its response. The board is in the process of reviewing the petition, so it will have the response to review. There will be some deliberations, And hopefully, within a matter of days, there will be a decision on whether a commutation hearing will be granted or not.
So it's essentially everything the same as last year's commutation hearing process?
There are some differences. In 1992, the legislature created some statutory language guiding the commutation process. Because Mr. Menzies was sentenced in 1988, those newer statutes will not apply. Essentially what that means is the board has very broad latitude in determining whether or not to grant a hearing in this case, because those statutes don't affect Mr. Menzies.
Can you expand on that a little more? How is it different, or what would be different?
So in the 1992 statute, this is 7727 5.5, the legislature outlined 3 areas that should not be considered by the board for a commutation hearing. The first are issues that previously were raised by the courts, issues that should have been raised in the judicial process, or issues that are subject to judicial review. So that constrain the board's considerations in cases that occur after 1992.
So in other words, the board this time has more leeway to grant commutation?
It has less constraint in statute, yes, that's true. I will say this, the board exists in a situation where it has the right to issue pardons and parole. That's part of its constitutional duty. Commutation is one of those main duties. What we are not are courts. So the board will stay in its own lane in order to promote the best functioning of government and will not attempt to relitigate anything that has been litigated in the past.
Can you speak to that statute that gives less constraint, the one that you just cited?
You're going to have to be.
Points of that statute, like the basis of that statute, that should not be considered for commutation.
So the 3 things that
A little bit better, that statute.
So 7727 5.5, the 3 areas that the legislature weighed in on said that the board should not consider for commutation things that were previously raised by the courts, things that should have been raised in the judicial process, or things that are subject to judicial review. Question?
We are looking at a timeline of just about 6 weeks. If there is a hearing, how long after that hearing do you expect a decision to be announced?
There isn't anything constraining the board in terms of the time, except that a decision will be made. If there is a hearing, a decision will be made as a result of that hearing prior to the 5th of September. Okay.
Is there a political thought behind commutation?
The board is an independent entity. It's not in contact with elected officials about this process. What we will consider is what is raised in the petition filed by the petitioner and the state's response.
There was some concern about Mr. Menzies' state of health changing rapidly. If there is a hearing and let's say his state changes after that, will there be any other action by the board?
So the judge has issued the death warrant. The judge has determined competency. Those things, unless changed by the court, will not be considered by the board. If there are no other questions, I thank you very much for coming.
Thank you.
There'll be a test.
Oh, don't say that.
Don't be. I grabbed a copy of